rules for oral argument pertain, which is that each side will get 15 minutes to argue, and there's no rebuttal. So once we get the, and there will be a clock that gets displayed in the image so that you'll be able to know how the time is going once we get started, okay? With that, there's a little bit of a time lag in terms of, I know this is a weird way to do argument, so sometimes it's a little bit hard to tell when someone wants to ask a question, and so we apologize in advance if you feel like we're cutting you off, but we'll try. We'll do the best we all can. All right, and with that, Mr. Curley, is it? I think. Are you ready to go?
Yes, Your Honor. Thank you.
Good.
Robert Curley for the appellant Brooke Brandt. And on March 7th, 2014, Brooke Brandt, while entering an indoor softball practice facility, was struck forcefully on the back of her skull by a softball bat swung by her teammate, the defendant, Meredith Ball. This resulted in a concussion with serious sequelae, both cognitively and visually, which has impacted Ms. Brandt's life to this day. This was not a competitive size field. There was no competition going on. There were no competitors present. Basically, what was involved were practice drills orchestrated and controlled by the coaches. There was safety equipment present in the form of batting cages that had always been used for hitting off tees prior to this day. And there were movable screens that were available to be used to prevent players from either being hit by batted balls or by swung bats.
Mr. Curley, this is Justice Maldonado. Can I ask you a question? You say that there was not a competitive size field, no competition going on, and no competitive players. Are you suggesting that when a team is practicing and gearing up for competition, that they should be less vigilant on their practices than they would be when they're in actual competition? Because it seems to me that when you're practicing so that when you get on the field, you win, and your practice has to be just as vigilant and forceful and competitive, and to be ready for when you get when you get out to actual play a game against competitors. So are you saying that you practice less competitively and do less than what you would have to do when you're getting out and actually meeting your opponents?
I don't believe I've ever said that in any time during the course of this case. People obviously need to practice hard, but a practice is a very different environment from the environment of a game. Practices can be subject to substantial control. And I think perhaps this might be a different case if, for example, there were an actual scrimmage going on or actual innings being played, as opposed to the kind of rotational drills that were going on, where batting could be controlled. And of course, we've got a batting situation here, which was highly different from what goes on in a game. Up to 3 batters were going to be using tees, and other batting activities were going on other parts of the field. It was the type of thing that could have and should have been controlled in a far better way, which is detailed in the affidavit of our expert, Sean Pender, which was before the court.
Well, ordinarily, counselor, the coach would have a duty of just ordinary care. I know there's a release here that prevents that. But when we're talking about the other players, you said a scrimmage is different. A scrimmage presumably would require gross negligence. What about a tackling drill? I mean, how do we draw the line between practices where I'm not talking about how the coach is supposed to set it up, but between the the teammates, how do we draw the line on what's a gross negligence situation and what's a negligent situation?
Well, as often happens in our profession, that is a factually dependent determination that has to be adjudged by the facts that are involved in a given situation. And I think this situation is well on the end of the spectrum of facts where simple negligence should be the standard. This is not a sliding exercise or that sort of thing. It is hitting, it's a highly artificial activity of hitting a ball off of a tee 5 feet into a net. And this activity was set up so.
Counselor, how are the players supposed to know when they have a duty of ordinary care and when they have a duty to avoid gross negligence? I don't know if we can really say to all the college players, it's very fact dependent on what your duty of care is.
Having done some college athletics myself, I don't think the thought ever went through my head what my duty of care was other than to act reasonably. I don't think any college athlete really thinks that they should do anything other than act reasonably. And then college athletes aren't going to make legal distinctions between gross negligence, recklessness, and negligence as we lawyers would.
Well, if it won't affect the behavior of the players, then what's the point of having heightened liability?
Well, the point, I suppose, of having simple negligence as the liability standard is that it does give the coaches and the players more incentive to think about how to structure a practice so as to avoid the kind of disastrous injury that occurred in this particular case. And I think that in the two Superior Court decisions that were before Judge Gilday and are before this court, the decisions by Justice Krupp and Justice Billings have indicated, I think in a cogent and reasoned way, that there are differences between practices and games. I am not saying that in a football scrimmage where people are actively involved in running at one another and tackling, that it might not be appropriate for the Garvin standard to apply. But in this kind of circumstance, I think the Garvin standard should not be applied. And it doesn't meet.
Yeah, I'm sorry. So what you're suggesting is that we start to draw a line between those practices that are scrimmage practices from those practices that are, just, I don't know, bad. I'm trying to think of how, when you're just kicking the ball, if in soccer, or when you're just putting in, even if you're putting in golf. I mean, there's a case that says, putting in the office. So you're suggesting that somehow we have to separate a competitive practice from a non-competitive practice, and how we start drawing the line. What if there's part and parcel where this part of the team is doing their little scrimmaging and this part of the team is, gearing up to sort of start batting?
Well, isn't that what the court did in Garvin? They articulated a rationale saying that we didn't want to impose a simple negligence standard on competitors, and in that case, of course, it was opposite teams, in an active game, because games should be played with enthusiasm and energy. But this situation is quite different from a competitive game. There was nothing that was going to diminish Meredith Ball's ability to swing at a ball by putting her in a safe position in a batting cage. A batting cage, of course, is a highly unusual kind of device, not used in an actual game. The batting cages were there and they were to be used for this kind of activity. and always had been used in this kind of activity in the past. Why should coaches or players be given an incentive to act unsafely in a practice when they have the ability to act safely?
Was there any evidence that Meredith Ball could change the way the practice was going, could bring out cages or disregard her coach's instructions? I didn't see
Well,
that.
there were two team rules that Meredith, at least two team rules that Meredith Ball did not follow. Number one, she was supposed to make certain that there was no one in the area when she swung her bat. Contrary to that team rule, knowing that the practice was at a time of transition, knowing that people were going to a stored equipment area outside the practice field, and that she was set up beside that area, and knowing that players were going to be entering the field, she nevertheless swung her bat and professes not to have seen the clearly visible Brooke Brandt. The second team.
I'm sorry to interrupt. Is there any, or what evidence is there that the coach, Davis, saw the plaintiff before saying go?
The coach, and the second team rule that I was going to get to in response to Judge Ditkoff's question, was that the coaches were affirmatively supposed to have determined that all players were in position before giving a go signal to start the next activity. There were only 13 or 14 members of the softball team roster, and both Brooke Brandt and her partner had left the field, were clearly not in position. They were in a position to be seen, and there is disputed factual testimony as to whether Coach Davis gave the signal to go or not. The purpose of the rule of having everybody in their position is obviously to have them in a position where they can practice with reasonable safety.
Wait, then I'm having trouble understanding maybe your case. Your case is that the coach did not say go to the batter?
That is part of the case, yes, Your Honor.
Where is there actually a dispute there? I mean,
Meredith Ball contends that she was given the go signal. Now,
Right.
if she was given the go signal and everybody wasn't in place, clearly there was a breach of duty by all of the coaches, and especially by Coach Davis, who was using the go signal.
Possible, but is there an issue? There's certainly evidence that the coach said go without all the players being in position. Is there evidence that Ball started, a genuine issue material fact, that Ball started swinging without being told to go? Davis in her deposition said she said go.
Ms. Brandt did not hear the go signal, does not believe a go signal was given, and actually said wait to Meredith Ball, because for the reason that she wanted Meredith Ball to wait until the go signal was given, and that was her testimony.
Well, your client said that she yelled wait, but she can't remember when she yelled wait, that she might have said it in her head, but she doesn't know how loud she said it. And as I was entering the field, I yelled wait and almost immediately felt myself being hit. So by her own testimony, that was the interrogatory actually, her own statements, there wasn't enough time between the wait and the swing for it to have any effect. I mean, am I missing something on wait here?
No, it was a very quick event, Your Honor. Obviously, Ms. Brandt was moving quickly. She was entering the field. She'd probably gone 8 feet or so into the field before she was struck from behind on the back of her head.
So is
Um,
your theory, are your theories of liability in the alternative? In other words, if the coach said go, then the negligence is on the part of the coach because the coach failed to check to make sure everyone was in position before saying go. But if the coach didn't say go, then it's the player who's negligent because she swung before there was the go signal.
Certainly, if the coach said go, that tends to favor the position of Ms. Ball. It certainly diminishes the position of the coach.
How do you maintain any kind of, I guess your claim would be, well, even if the coach says go, then the player needs to nonetheless also check herself to make sure that the coach's go signal was justified?
The player still has an affirmative duty, excuse me, to make sure that the area is clear of other players before swinging. And she did not do that. And it's because there are these differing views of the facts that this case is particularly appropriate for a factual determination by a jury that was not, which was obviated by the summary judgment decision. I have a time expired.
Yes, you do.
But I have
And
just
I'm
one
just
question.
going to check to see if there are any questions.
I do. Does it, I understand you're saying that there's a dispute of fact that then makes this go to the jury. Does it make a difference what standard we're applying, ordinary negligence or the heightened negligence, as to whether there's a dispute of fact, whether the dispute of fact makes it more likely that it should go to the jury?
I don't think so, Your Honor, and I think we have explored that in considerable detail in both our original brief and our reply brief.
Let me just see if everyone is set for questions. All right, thank you very much, Mr. Curley. Who's
Thank
going
you,
to
Your
be
Honor.
who's going to be arguing first on as between Mr. Smith and Mr. Lynch?
I believe Mr. Lynch and I have agreed, as we did below, that I would go first, and no pun intended, he would back cleanup.
All right, we're ready whenever you are.
Thank you, Your Honor. May it please the court. Robert P. Smith from DeMora Smith with DeMora Smith LLP, privileged to represent Coach Davis from Suffolk University in this matter. I have nothing but great admiration for Mr. Curley and his advocacy, but everything that he writes and says about this case, at best, would be a simple negligence case. And
I'm sorry to interrupt you. There's like a feedback that's happening on your end, which sometimes happens if there are two devices with the microphone on.
that is not the case, Your Honor.
Okay.
I would, if it continues, I would be happy to put the headphones on.
No, that's okay.
All right, thank you. In any event, my great respect for Mr. Curley and his efforts to shoehorn what at best is a simple negligence case to meet the standards of Govan, trustees of Boston University, and most especially the Massachusetts Appeals Court just in December in Barella 18P 322, a decision that came down as Mr. Lynch and I were filing our briefs, and we supplemented it with the appropriate letter to the court to draw this panel's attention to that decision. There is not a material fact about anything in this case that should cause this court to ignore well-settled precedent from the restatement, Govan, Kavanaugh, and the host of SJC and appeals court decisions we've cited. Let's keep in mind, oh, and by the way, more importantly, on the practice thing, the release signed by this highly competitive NCAA athlete, similar to releases she had been signing her entire life for her parents, had been signing for her entire life because she's played the sport since she could walk. Specifically includes practice. And this was a practice that was designed to, specifically designed. They were about to start spring training out of Florida. This practice was designed specifically to mimic pre-game practices where they go to the field of the opponent in Florida. There are no batting cages or screens around, but in the moments that they have to prepare for battle, if you will, they hit off tees into fences and other places. There is no material proof in the record that the tees were not appropriately spaced. My brother Curly says, well, it was the tee next to the door. Well, it was the tee nearest the door, perhaps. But the coach, the assistant coach, Ms. Ball, all testified that there was plenty of space between the tees for safe operation by the hitter. And then you had, I'm sorry, yes, Your Honor.
Certainly a jury could find that that wasn't true, and there's an expert opinion for the plaintiff that says the tees were poorly set up. And when you add that to Coach Davis's failure, Coach Davis's failure to make sure everyone's positioned, in fact, instructing her players to start swinging when they planned they were not all in position, why isn't that enough to get us to gross negligence? The combination of the poor setup of the tees and saying go before the players are ready.
Well, because there's certainly no evidence, and it was Mr. Curley's burden to come forward once we made our motion for summary judgment with competent evidence sustaining the gross negligence and recklessness standard, which applies in this case. His 11th hour expert from the Cincinnati Reds had no basis upon which to issue that opinion. Justice Gilday dealt with it quite well, I think, in the footnote in his opinion, where he accepted it over our motion to strike, but didn't pay any attention to his conclusions of law about whether something met a standard or didn't meet the standard. The go or no go, it again goes to simple negligence. When you look at the language of the controlling cases, the adjectives.
I'm sorry to interrupt. I have a couple of hypotheticals for you.
Certainly.
If the coach saw Ms. Brandt being behind the batter, Ms. Ball, in a place of danger, and nonetheless said go, would that be enough in your view to get past summary judgment?
Well, like all hypothetical questions, Your Honor, had the two young athletes been standing back to back in close proximity before she said go, I'm sure she would have instructed them to separate, but there was no opportunity to do that. There was no opportunity to
I'm just
observe that.
asking for an answer to my hypothetical, please.
As I sort of modify it by saying if they're just standing there waiting for something to happen, I think you have a better
Right.
a better claim. But there is no evidence.
But I'm not talking about the facts of this case. That's why it's a hypothetical. It's a hypothetical. Okay. So we can agree that if the coach had actually seen the plaintiff in a zone of danger, i.e. being close enough to be struck by the bat, and nonetheless said go, that would be sufficient to get past summary judgment on the question of recklessness. What about if the coach has a duty to make sure that everyone, all members of the team are accounted for before saying go, and doesn't do that? Would that be enough?
No, Your Honor, because it's a fluid situation. People are moving and rotating from stations to tossing stations.
Right, but isn't that the point of having, having an obligation to make sure that everyone is where they're supposed to be?
She instructed them how to do it. She had no opportunity to observe Ms. Brandt at all prior to this instant accident, caused in fact by Ms. Brandt's own lack of regard for her safety. So no, it doesn't meet the standard. People are coming and going all the time during the live practice.
All right, so
But they're
here's,
not coming
let me
with great
tell you
speed.
frankly, excuse me,
Your Honor.
let me tell you frankly, what bothers me in your responses to my hypotheticals is
Mhm.
when I ask the hypothetical, you respond with contrary facts, in your view, contrary facts in the evidence of the case. And what I therefore hear and take from that is that the case will depend on whether the version of the facts you present is credited.
I
And,
respectfully
and that
disagree.
seems to me like a, you know, sort of classic example of something that then needs to go to a jury.
I respectfully disagree, Your Honor. The material facts in this case are simply not in dispute, and they don't rise to the level of a well-established standard in this court and against my client as protected by the release given by this highly educated, highly skilled student athlete.
Okay, let me see if there are any other questions for you.
Not from me.
No? All right, Mr. Lynch,
Thank you.
thank you for your argument.
Yes, good morning, and may it please the court. My name is Paul Lynch. I represent Meredith Ball. She was the batter on the day of the loss, and I never played competitive college sports, but I did coach my two daughters. They're 6 years apart, and I coached them from first grade up until they started high school, and I coached basketball and soccer. And most of the time with 5th and 6th grade girls, it's like herding cats. But one of the things that we focused on and we had to emphasize at every practice was you practice like it's a game, meaning that every drill you do and every scrimmage is supposed to be played with game-like intensity. And if you extend what Mr. Curley is saying down to this level of practice, you're going to have a situation where people won't compete, and that will be reflected in the games, and it will be reflected in I suppose probably the danger. The better prepared you are for the game day, the less likely you are arguably to get hurt. Now, the only other thing I wanted to emphasize, other than what's in my memo, is the idea that batting off a tee is not in itself something that requires competitive intensity. And I would just submit they don't bat off a tee. They don't take batting practice off a tee just to kill time. There's a specific reason why they practice their batting, because in a game, in a real game that they're trying to simulate, the focus is important. It has to be emulated, and it has to be drilled, and their form has to be drilled, their batting stance, the grip on the bat, their follow through. All of these things have to be practiced, and it's through this repetition that they prepare for the games. Most of an athlete's time is spent in practice, not in games. And so I think it's improper to say that for some reason that we should draw a line on that, or Miss Ball should have made some distinction between when she's in a game and she's supposed to be focusing on all of these components that make up, you know, proper form.
How does this help? I mean, I was not a baseball player.
Yes.
But it seems to me, whether it was a game or a practice, in neither scenario are you supposed to have another player standing close enough to the batter to be hit in the head by the bat.
That's true. But
regardless,
sure.
Right? So, I mean, however much you want to either distinguish practice from game or ally practice with game, in either scenario, this injury should not have occurred in the ordinary course. Someone should not be hit in the back of the head by a batter who hasn't let go of the bat, right? I mean, the bat was in the batter's hands.
Sure.
So this wasn't a case where, you know, after the swing, the bat went flying and it hit someone in the head.
No, but it was on the follow through. So in other words, the batter.
Sure, but and I don't believe, but correct me if I'm wrong, was there evidence that in the ordinary course of playing the game of softball, that one player is supposed to be within the arc of the batter's swing.
Well, no, that's not,
Right.
but of course, the evidence is that Miss Brandt ran into the path of the bat, and that she ran in from a position where she was behind my client, who hit her with the follow through. In other words, she had her back turned, and she did testify in her deposition that before she got into her stance to take her swing, she did look behind her. She did look around. So the question is, and maybe I jumped the gun on what I was saying, talking about this distinction with practice, is what I'm trying to get to is the underlying rationale for the Govan decision, which is chilling competitiveness of practice, because I thought that Mr. Curley was making the argument that for somehow batting off a tee was different. And that's what, because I know I addressed a lot of these other issues in my memo, I wanted to go right to that point. So I wasn't offering that for anything other than to say, batting off a tee is something that requires focus, and it should be given the protection of the higher recklessness standard, because it really, you can't parse this down into individual drills, as I know some of the questions were. You know, every aspect of a sport is competitive, and every aspect of a sport carries with it some risk. And when these players consent, and when these coaches consent and to either coach or play, they are consenting to certain things that happen. What they're not consenting to is this recklessness. This is almost intentional behavior, and there's zero evidence. I think that the judge was very on point, that there was zero evidence that, particularly as to my client, that there was anything that rises to this greater standard of recklessness in her conduct.
What if she took a swing before the coach said go?
They do that. I think arguably there's a negligence claim there, Your Honor, but if she was swinging prior to, maybe negligence, but certainly not gross negligence, certainly not this, you know, given the fact that she had looked around behind her, and you don't expect that a player who is supposed to be focusing on a tee is going to be looking behind her, then looking behind her again, because she's getting ready, because on that chance that someone may have, since the last time she looked around, that someone is now encroached in her space of her bat. It's just not, it's not.
No, but maybe I'm misunderstanding. What's the purpose of having the coach say go? To me, it seems like it would be sensible that the purpose of that is to protect the player, so that the player doesn't have to do just what you were saying, which is check behind herself multiple times.
Sure. Again, I would agree with that, but I think as applies to the batter, I think that failure is, if anything, is negligence. It does not rise to that level of gross negligence, because that would imply that she's somehow supposed to expect that Miss Brandt has come into her space and swung anyway. And
I don't understand that point. It might be just enough that she is supposed to expect that she has to wait for the coach to say go.
Well, I mean, you know, people take practice swings all the time in baseball. You know, they don't even only swing once they get up to the bat. They're taking practice swings all the time, because again, it's the form. And so I would, and maybe I'm not following the question, because I think that at the end of the day, that if anything, that's negligent. It's not gross negligence.
Let me see. I think I understand your argument. Let me see. Are there any other questions? No? Well, thank you all for joining us. We know that this is probably a little more cumbersome and less convenient than in-person argument, but it is very helpful to us, and the case is very interesting. And with that, we're going to take it under advisement. Thank you. I think you can
All right, we are live streaming.
Good morning, everyone. Welcome to the sitting of the Appeals Court. This is case number 2019 P1151, Dmitry Shutov, this LD Associates, Inc. We are your panel this morning. I am Gabrielle Wolohojian. With me is Justice Maldonado and Justice Ditkoff. And we appreciate your participating in this argument by video conference. We have the ordinary rules of argument for these sittings, and that means each side gets 15 minutes to argue. There is no rebuttal. You may assume that we have read your briefs and we're familiar with the record. There will be a clock that appears in one of the windows on your screen that will tell you how much time you have left. It's the ordinary clock you would see in the courtroom. And with that, we may begin. And Mr. Hochberg, I believe you are representing the appellant. Is that correct?
That is correct, Your Honor. Yes. If it please the court, my name is Andrew Hochberg. I represent LD Associates with my firm Hochberg and Associates. This is an appeal that was brought forward in an effort to correct what we believe to be clear error by the lower court, and also to preserve and protect the reputation of the appellant, who is a builder, has built more than 350 condominiums in Berkshire County. It's an appeal from an order issued by the Housing Court Western Division. The action began as a small claim in Housing Court, alleging damages of $7,000 in the small claim. But in fact, in the Consumer Protection Act demand, the claim damages were $8,500 plus diminution in value of this condominium that the plaintiff's appellees had purchased in some substantial amount. The claim was substantially unsupported and unsupportable, and the evidence at trial and the finding at trial demonstrate that. On appeal de novo, after a motion of reconsideration and a request by the appellants to retry the small claims, the damages proven were $1,960, and this included the $1,040 that we are here appealing today that was ultimately doubled and attorney's fees were added. We claimed this finding was clearly erroneous. Pursuant to the Consumer Protection Act, the court doubled damages, added legal fees for a total award of $8,920. We appealed the $1,040 award plus the attorney's fees associated with it. So the threshold issue I want to speak about is the standard of review. The appellee's brief rests upon a premise that is contrary to the actual standard of review. They argue that determinations of a lower court must stand where there is conflicting evidence before the court, but that's not the standard of review. They cite no case in support of this conflicting evidence standard. The standard of review is the clear error standard, and a finding is clearly erroneous if some evidence supports it, but the entire evidence leaves the reviewing court with a definite and firm conviction that a mistake has been committed. It's our position that a mistake has been committed. Thus, the mere fact that there's some evidence that exists on each side of an issue doesn't preclude a clear error finding on the part of the lower court. In our case, we believe there is absolutely no conflicting evidence. The undisputed evidence, the documentary evidence, is as follows. It's Exhibit 2, 5, 6, 7, and 8. Our position is those are the key issues that go to the notice requirements that affect.
Can you tell me where in the record I'll find any place where you raise the issue of notice with respect to these two particular repairs down below before the verdict?
Before the verdict, absolutely, Your Honor. First of all, the notice is the burden of the plaintiff.
I know, I'm looking for record citations.
I don't have
pages.
I don't have those record citations.
I've read the entire transcript. So that requirement of notice, you're absolutely correct. It's the burden of the plaintiff, but it's also waivable.
We never waived it. Certainly.
It can be waived by not being raised. So that's why it's important to me to know exactly where you raised it down below.
We did not raise it down below. We addressed the issue of notice.
So how can, if you did not raise it before the trial judge, how can we say that it was error for the judge to the judge to find liability when there's an element you just hadn't contested at all. That it just,
Well, I
it
would,
didn't get contested.
I would suggest we did contest it because the evidence indicated that we addressed issues of notice and we examined the issues of notice on each count.
Where that again, I need, because I have read everything that you've put in the record.
There
and
was
I
no
don't
objection
see
made.
that.
There was no objection made to it, but there certainly was testimony and cross-examination on each item of evidence. So when
But
we go
I
through,
didn't see, is there evidence that where anyone said, I never received notice of this particular issue? I didn't
believe-
see that testimony.
no, but there was evidence that said, but this was the notice that you sent.
Yes,
that's
I
all that-
agree.
that's-
I agree with that. And I agree with that.
And
But
that's
judge
as
said
far as
that
it went.
it doesn't look like the issue of notice was joined down below.
There, Your Honor, I would respectfully disagree because it
Then
was,
tell me where it was.
well, again, at each point when we addressed Exhibit 2, Exhibit 5, Exhibit 6, 7, and 8, when we looked at those issues, and we talked about what was in those issues, that's where we addressed the issue of notice. But again,
So
it's the,
where, can you give me the record pages where you say those, where that was sufficient to inform the judge that you were contesting notice?
but we weren't contesting that there was notice because there was notice, but the notice went to specifics. So for example, just on the issue of the mix of paint, the notice went to the specific of, this was a notice for the stairway, halls, and walls. So we talked about that. And when Mr. Shotov testified on page 91 of the transcript, but 93, 94 of the record, Mr. Hashem said, was there an issue with paint in one of the bedrooms? Is that correct? Correct. And then he talks about two different paints on the wall. And then Mr. Shotov says, after being shown Exhibit 11A, which is a picture of the mixed paint, allegedly, that's what I'm referring to exactly. That's that. There's no question. Wait for my question. He says, this would be 11A. This describes the left front corner of the living room and it's joined, it's a juncture of the wall. So he defines what the notice was. He defines what the notice was, because we didn't contest that he didn't give notice. The exhibits I mentioned, Exhibit 2, 5, 6, 7, and 8, are all adequate notice, absolutely adequate notice of what's contained in those exhibits. And we address that. But when we see it, a finding after, when we receive the decision, that there's a finding of $1,000 to paint the bedroom where there's never any notice of that, that's a failure of the plaintiff to prove its case. So the fact that, and we never specifically waived notice, nor do we contest that those exhibits, those writings required by the contract were sufficient notice as to what they addressed. With regard to the concrete on the floor, the $40 claim, we don't contest at all that there was more than adequate notice, that there was issues with the garage, and that's Exhibit 5, the punch list of November 9th, 2013. But in Exhibit 8, on the very last page, Mr. Shotov has typed up a list of every single item that he addressed in Exhibit 5, and for items 27, 28, and 29, he says those items are done. So that's the notice. We don't object that there was insufficient. Excuse me. Yes.
After all the evidence came in,
Excuse me.
after all the evidence came in, what did you argue to the judge on why he should fine for your client?
We argued that we contested the credibility of Mr. Shotov. We contested the issues about whether the paint was actually mixed or when it was actually mixed. We contested the issues of we didn't say there was no notice. We said that we contested there was no mixing of paint. We were focused on at that point the fact that we had complied with the warranty issues. We contested the issue that there was 2 coats of polyurethane on the handrails. But that's not an issue we're contesting on appeal. That was an issue where there was evidence, and we don't think it was clear error. We presented contrary evidence, but the judge was certainly within her discretion to make that finding. But as far as $1,000, when Mr. Casella, who was the plaintiff's expert, said maybe $1,000. I never saw a mixed paint anyplace else but in the bedroom. When he said that, which didn't come in until the end of the plaintiff's case, when he said that, we thought, well, that's fine, but that's not what he told us. He told us stairway, hall, and walls. So we argued for the stairway, hall, walls. We did address that. And the finding was, especially because Mr. Casella said, I never even saw any mixed paint anyplace else, contrary to Mr. Shotov's testimony. Our focus was that we had done what we had been asked to do. So we've been asked to do with adequate notice. That adequate notice was certainly there, and it was with specific stairway, halls, and walls. So that's what we focused on. So we were focusing on what.
Did you move for, you did not move for a directed verdict?
Did
on
not.
On the ground that there was insufficient evidence of notice?
Through the trial, we were focused on what they had asked us for and what we had proved. We had presented evidence that we had painted the stairway, hall, walls.
So that's why you're saying the judge's findings clearly erroneous, because they focused on evidence of the bedroom, but that wasn't part of the case, you're saying.
That's exactly right. That's exactly, and it was also when the appellee argues conflicting evidence, the conflicting evidence is between the plaintiff's testimony. Mr. Shotov said the mixed paint was in the living room. That's what we focused on. He gave us notice of that, and if the judge found that there was mixed paint in the living room, we wouldn't be here today. But the judge didn't find that. The judge found that it was mixed paint in the bedroom. We never even focused on that because we were focused from Exhibit 8 and from Mr. Shotov's testimony that the mixed paint was the stairway, hall, walls. And it was our position in Mr. Burton's testimony that and the evidence from his bill, Exhibit 25, I believe, that he had done that work. So that was our focus, and our focus was, you gave us notice, we did what you asked us to do. So there were some that clearly we hadn't, but that's not an issue for appeal on this appeal. So we had addressed those issues substantively and on the facts, but there was never any evidence of what the cost to paint the stairway, hall, walls were. So we thought at trial they failed to prove any damages for the stairway, hall, walls. We moved on to find when we received the decision that it was a finding in the bedroom, which was contrary to what Mr. Shotov said. That was a surprise to us at that point, but it's still the plaintiff's burden. So, and again, as far as the garage is concerned, there was clearly notice, there was adequate notice that there was excess material on the floors in the garage. No question about that. That's Exhibit 5. But when we have Exhibit 8 and Mr. Shotov, undisputed, there's no conflicting testimony here. Mr. Shotov says, you did it. 27, 28, 29, those items on the last page of Exhibit 8. You've done it. We moved on. So there was no reason to object because we were dealing with a substantive issue, the evidentiary issue. And we thought we had addressed that to find that we have an award for damages for the garage. Again, we say is clearly erroneous. We also, as I indicated earlier, the review of the evidence is there was a notice of defect given with specificity in Exhibit 8. Mr. Shotov testified it was where he said it was in Exhibit 8. That's what our focus was on. Mr. Casella claimed he only saw it in the bedroom, and we thought that at that point it was conflicting with Mr. Shotov, but it wasn't conflicting with the defense testimony. But it was consistent with Dana Burton's testimony. Dana Burton was offered as showing conflicting testimony because he was in the home, but he said he didn't see it. So that's just negative testimony. That doesn't add or subtract anything. So we say it is clearly erroneous, and because those two findings were clearly erroneous, in our opinion, we suggest that the award of attorney's fees particularly because the Consumer Protection Act demand, 93A, the 93A demand, which is Exhibit 15, mentions nothing about mixed paint, nothing about concrete on the floor. So we suggest that that finding is erroneous also and should be adjusted. There were findings that there were breaches of warranty. There were findings that they were covered by the 93A demand. We don't doubt that at all. And there should be an award of attorney's fees, but not the $5,000 award that was entered. Thank you very much.
Let me see if there are any questions. Nope. All right. Mr. Hashim?
Good morning, Your Honors. My name is Michael Hashem. I represent Natalia Shutoff and Dmitry Shutoff. Thank you for hosting this by way of video conference. There's nothing in the record that was brought up prior to the judgment that the issue of notice from a legal standpoint was ever at issue before the court. The first time that the defendant raised the issue, the legal issue of sufficiency of notice, was by way of a post-judgment motion for reconsideration, which the judge denied. That's the first time that you'll find anything in the record about the question of sufficiency of notice.
Well, it seems to me that he's not arguing that he's saying that was because that wasn't part of the case originally. And then the judge all of a sudden came out with this finding that then caused them to then sort of go back to the judge and say, no notice on that. That wasn't part of the case. You just pulled that out of the air, let's say.
Well, he's arguing the facts to you now, and with all due respect, I think it's the purview of the lower court to decide the facts. And in this
unless they're clearly erroneous, right?
Excuse me?
Unless they're clearly erroneous, which is what he's arguing.
And we obviously, yes, you are correct, but we disagree that there's clear error here.
Where is the notice of these two particular defects, the written notice?
The written notice was delivered by Mr. Shutoff on July 8th. It's exhibit number 8.
I've got that up on my other screen. Which are you talking about? Which page of that? Which page of the record? Is that page 47?
I believe it's 55. No, I'm sorry, Your Honor. It's 45 to 52 is that letter. It's a lengthy letter.
I see the letter. So where does it say anything about the paint in the bedroom?
It doesn't mention the paint in the bedroom, Your Honor.
Okay, so is there any place else that there was written notice of a problem with paint in the bedroom?
He doesn't specifically, Mr. Shutoff does not specifically complain about the paint in the bedroom, but he does say the paint in the hall.
What I see is flat and semi-gloss paints are mixed on stairway hall walls.
Correct. And
Okay.
our argument.
So just so that there's no ambiguity about what is or is not in the record, you would agree that there is no written notice regarding a problem with paint in the bedroom?
Correct, Your Honor.
And is there written notice regarding this concrete on the garage floor?
I think that's a different question. That was listed as part of the punch list. And I don't honestly think that notice was required under the punch list, because the punch list was arrived post-closing of things that the contractor never completed. So it's not a question of whether he was given notice on those issues. It's a question of whether or not he performed.
What page is the punch list?
A punch list is typically done when you get to a closing.
No, the page in the record.
Oh, the punch list was exhibit number 5, record at page 36, Your Honor.
All right, I just want to make sure that I see the exact language that you're relying on.
Well, as far as the punch list goes, it basically says that the garage needs to be cleaned. And again, this supports our argument, not only with respect to the cement, but with respect to the mixed paint. It's the question really, the defendant tries to frame this as a question of condition precedent. He tries to say we never gave notice of these issues. The real question is, was this notice sufficient to give the defendant, notice that there was an issue here that
Well,
required.
there's a certain, in the contract, we have to, I think, start with the language of the contract. It says that, there's a warranty provided that within 1 year period, the buyer gives the seller written notice specifying exactly the nature of the defect. Now, so that's what we're looking for. And as I take it, with respect to the garage floor, you're pointing to the punch list.
Correct.
And with regard to the paint in the bedroom walls, you can't point to any written notice.
I'm suggesting that exhibit number 8 is sufficient notice under the law to apprise the defendant that there's an issue.
Of the quote, exactly the nature of the defect.
I would suggest that it gives the defendant reasonable notice that there's an issue here. His painter was in the unit for approximately 6 to 7 days, and they had plenty of opportunity to view this issue. And I think that's what the.
When you say view this issue, are you suggesting view the issue of the bedroom or view the issue of the stairway hall?
Both, Your Honor.
But what difference does that make if your warranty is conditioned on your providing a particular form of notice?
Well, I think we satisfied that by saying that it was a question of mixed paint in the stairwell hall wall. How you interpret that is maybe open to question. And maybe the reasonable thing for the defendant contractor to do in this case would be to contact Mr. Shutoff and say, where specifically is the issue? Of course, that never happened because he basically ignored all the notices that he received from Mr. Shutoff. So he had reasonable notice that there was an issue here with the paint in this unit. His painter was in the unit for 6 or 7 days. And if you see the testimony that we cited in our brief, you'll see that he said that he basically denied there was an issue. So the defendants denied any problem with the mixed paint, not that they never received notice of it.
And so that's the contractor. But what about Mr. Hochberg? The magistrate Fenn's damages doesn't include anything but upstairs paint or concrete in the garage. The small claims complaint doesn't say anything about that. How does Mr. Hochberg know that he has to defend the upstairs paint and the cement in the garage?
Because that was the testimony we presented at trial. My client testified, as did his painter, the person who corrected the repairs, testified as to where these issues were. He testified that it was, the paint in the bedroom was mixed paint in the corner, and Mr. Casella, who corrected the problem, testified about that. And that was an issue we tried during the trial of the case.
But if your claim is a warranty claim, right? It's based on the warranty provision of the purchase and sale agreement.
I would agree with that as to the paint, but I don't necessarily agree with that as to the cement. I would suggest that the cement claim is based on a breach of contract, a simple breach of contract, because
Which provision of the contract?
And they said, these are the things that remain to be
Excuse
done.
me.
And one of the things was clean the garage floor.
Excuse
How you
me.
interpret that is another question, but because
Am I the only person who's having connection issues?
And I think we've lost Attorney Hochberg.
Yeah,
Attorney Hassan.
Hassan.
I can hear. I think Mr. Hashem is, Attorney Hashem is frozen.
I can remove him to the waiting room and try to readmit him. Yes. Oh,
cut out, Your Honor.
You did. Sorry, we lost you there for a little bit. My question to you was, Well, if you're not relying on the warranty for the garage floor, but you're relying on a breach of contract, which provision of the contract are you relying on? Can you please point it out to me?
Yeah, the punch list, exhibit number
The
5.
punch list wasn't part of the contract, was it?
No, it was a post.
Okay,
agreement.
so what is there any provision in the purchase and sale you're relying on for the repair of the garage floor?
The purchase and sale makes provision for a punch list. If there's things not completed prior to closing, the purchase and sale makes a clear provision for a punch list that the two parties are to prepare, and that's what was done. And the punch list basically is a new agreement that says, okay, Mr. Contractor will correct these various items, and that's what was supposed to have happened.
Within 45 days of closing.
And it never did happen within 45 days. I don't think it was corrected for well over nine months or so. So we think both of these issues really come down to sufficiency of notice, and there was conflicting evidence on that. As I said earlier, the court was within its purview to find that in favor of our client. The standard, contrary to what my brother suggests, is whether or not the judge was clearly erroneous in making her findings. And when there are two permissible views of the evidence, Your Honor, the fact finder's choice between them cannot be clearly erroneous. And I call your attention to the Goodman case that's cited in our brief, Goodman versus Atwood, decided by this court, 78 Mass Appellate Court, 655. So we feel that the notice was sufficient to reasonably put the defendant on notice. All of the cases cited by the defendant in his brief really have no applicability to this particular situation. They really deal with completely different fact patterns that can't be applied here. There's one that deals with the specificity required under a bond. That's the Greenfield case. And the other case deals with a federal contract awarded by the Navy for a very highly technical problem. It's a notice to cure. In view of the fact that, when a notice is given, it's required to reasonably appraise someone of what the issues are. And I think it's incumbent on them to at least do some investigation to determine whether there is an issue and where the issue lies. Based on the defendant's testimony, his contractor painter was in that unit for over 6 or 7 days doing all sorts of touch-up paint, and he had reasonable opportunity to observe it. However, his position in court and trial was that he denied it even existed. And that's where the conflicting testimony is. And as long as the judge's findings are plausible in light of the entire record, with all due respect, the appellate court should not reverse, and that's been set forth numerous times in the Moulis case, not only here, but in numerous cases. The appellant never raised this issue at trial from a legal point of view. He never raised the question of the sufficiency of the notice, or whether notice was given at all. Here he raises it as a condition precedent to recovery. He says that we never gave any notice of this issue, and that's I don't necessarily agree with that, Your Honor. I think that we gave notice. The question for the court is, was the notice sufficient? And in our view, it was, because it reasonably apprised the defendant that there was a problem with mixed paint in the upper bedroom. And I could also suggest that the court could look at the language of that letter of the July 8th, 2014 letter to say that it's not clear that it's exactly limited to the stairwell, which again puts the defendant on notice to do some investigation, which the defendant did not. you know, where there's a question, mixed question of fact here, I think some deference needs to be given to the judge's findings.
I think we have your argument. Let me see if there are any questions. No? All right.
I would also like to reference the court to the exhibit, which is the exhibit of the picture of the mixed paint, which is attached as a supplemental appendix to our brief. That's at page 12. That's reflective of what went into evidence. The appellant's picture attached to his appendix is black and white. We introduced a color photo that showed the actual mixed paint, and that's what was viewed by the court.
And that's the mixed paint on the stairway hall or in the bedroom?
It was in the bedroom, Your Honor. It was testified to be in the bedroom by Mr. Shutoff and also by his painter, Mr. Casella. I would suggest in closing, Your Honor, that there's no clear error here. There's no abuse of discretion. The appellant's arguments are without merit and require that this court confirm that the judgment below and award the appellee's costs and attorney's fees as requested in their brief. And unless you have any questions, I'll rest on my argument.
I don't think I see any, so I want to thank you both for your arguments. It was very helpful to us, and it's an interesting case. So I'm going to ask if you'd both leave this meeting and